Hello and welcome to Infocus. I'm G. Sampath. The Right to Information Act was a historic piece of legislation when it was first introduced in, I think, 2005. Now it's been 20 years and a lot of impact has been made in public discourse through this act. But successive governments have tried to dilute the power and provisions of this act over the years. Now, the latest blow to the Right to Information Act has come in the form of Section 44(3) of the Digital Personal Data Protection Act. Now, this was an act that was passed in 2023 and its rules are said to be notified sometime this month, and once the rules are notified, it will come into effect. So how does this Section 44(3) of the Digital Personal Data Protection Act actually weaken the Right to Information Act? Because a lot of activists and journalists too and researchers who have been using the RTI for getting information out from the government have raised a lot of concerns. So how exactly does this provision of the DPDP Act work? And if it stays and if it doesn't get repealed as is being demanded by many, including the opposition, what does it mean for citizens? To explain this issue in great detail and to sort of explore the implications of what are the issues around it, we have with us someone who is a very familiar figure in the realm of transparency and accountability in India. She is the co-convenor of the National Campaign for People's Right to Information and the founder of Satark, Nagarik, Sangathan. Anjali Bhardwaj. Anjali, welcome to the pod.
Thank you, sir.
So Anjali, to start with, I was just wondering if you can explain for our listeners what exactly is this Section 44(3) of the Digital Personal Data Protection Act? Why is it raising a lot of concerns among activists, researchers, journalists, and everybody else who is sort of depended on the RTI as a tool to sort of hold the government accountable? They are very worried. So what is the problem?
So, if we were to look at the Right to Information Act, it came in 2005 and it has empowered people across the country to be able to access information from the government, which they have used to demand accountability from governments. And the law, even when it was being drafted, there was a lot of care that was taken to balance out the right to privacy and the right to information. The Supreme Court has held that both are fundamental rights flowing from the Constitution, and the Right to Information Act in Section 81J basically states that personal information cannot be provided to citizens if it does not have any relation to public activity or interest, or if it causes an unwarranted invasion of the privacy of an individual, unless there's larger public interest. So, Section 81J, in a sense, was very nuanced because it stopped any vicarious seeking of information. Anybody walking into a public hospital and demanding records just because it is information that is held by a public authority was prevented, these kinds of things. However, what it did clearly factor in was that there's a lot of personal information, the provision of which to citizens is important for accountability, for public accountability, for preventing corruption from taking place, abuse of power, and therefore that was the information that we could get. So, for example, information about loan write-offs. We know how very large capitalists have been taking loans and they've been sort of, running away, and the public sector banks have been writing off these large loans. People have filed right to information requests to find out the names of these people or companies who are getting these loans. Now, this was very important because although it is personal information, there is a larger public interest. The courts have also held that this does not count as unwarranted invasion of privacy. What the data protection law has done, and the data protection law has been brought in the name of protecting the right to privacy. What this law has done is, through Section 44(3) of the law, it has amended Section 81J of the Right to Information law. It has done away with all the nuance, and it basically now says that all personal information will be exempt from the Right to Information Act, the purview. So that means that if we go and try and access information that has any kind of personal information, the government will turn around now and say that, look, the law has been amended, the RTI law, we cannot share it with you, which is going to have very, very serious implications on the whole framework of transparency and accountability in the country.
Right. So, does the law define anywhere what constitutes personal? Because when a politician's assets are sort of arguably personal information, but they are sort of proactively shared in the public domain. So, is there any definition of what is personal, as in personal that has a bearing on public interest, vis-a-vis personal that doesn't have and therefore can be withheld, or is it like a sweeping definition of personal as anything and everything about a person who holds public office might be classified as personal? How is it defined?
Yes. So the data protection law basically defines personal information as any information that identifies an individual or an entity. So that basically means that anybody's name, their address, any other details, everything is personal. So, and also in the Right to Information Act, there have been several judgments from the Supreme Court itself where personal information has been defined very broadly. So we are therefore now at a point where, when this section 44.3 of the data protection law becomes operational, uh, we will it will become impossible for citizens to access any information which can be defined as personal, which would include, for example, names of beneficiaries, which are very important to be in the public domain for people to demand accountability. Like I said, names of people who are taking these large loans which are being written off, a whole host of other information where granular information has so far been provided to citizens will now be outside the purview of the RTI Act.
Right. So, in the RTI Act, you made a mention of Section 81J, which is a key provision that is sought to be sort of amended by this Section 44.3. And one way it is amending is to sort of expand this privacy-based exemption to a very sort of ridiculous level. The other way, I think, refers, what it does, I think, is to quote from this RTI clause. It says that the Section 81J also says that, I quote, the information which cannot be denied to the parliament or a state legislature shall not be denied to any person. This makes sense because those who are sitting in the parliament or legislature are representatives of the people. So what you can share with the representatives of the people, you should be able to share with the people whom they represent. Now, in this amendment, according to Section 44.3, even this information which can be shared with parliament will not be shared with the people. Is that correct? I mean, and can you share the kinds of examples of this kind of information which citizens may no longer be able to access?
So, Sampath, there are two things. One is, of course, that this was a very important proviso. Some provisos have been given in the Right to Information Act to minimize the exemptions to our right to information. And this was one which actually has been misunderstood by the government to be only for Section 81J. There are many judgments of various courts, including the Punjab and Haryana High Court, where they have interpreted it not to be only applicable to Section 81J, but to all the exemptions in the Right to Information Act that are listed in Section 8. What this essentially means is that it's equating, in a democracy, citizens with their elected representatives. And the spirit of the law was really that, public authorities are simply custodians of our information. So in a democracy, we can have access to information. Only some kinds of information can be exempted. Now, this particular provision has been read under the data protection law as being only applicable to Section 81J, and it has been deleted. Now, this will be a big problem because there have been many cases in which RTI applicants have actually argued not just for Section 81J, but also for the other sections in the exemptions, that they should be provided the information, because this information would be provided to the state legislature or the parliament. So, for example, in the Punjab and Haryana High Court, for example, a matter reached where somebody was denied information on the number of LPG cylinders that were given out, the criteria on the basis of which allocations were made, the procedure, even the lists of people. And finally, the court ruled that
On what grounds were they denied that
they were
information?
denied this information on the grounds of fiduciary. They were denied this information on commercial confidence grounds. And the Punjab and Haryana High Court held that this particular proviso, which says that any information that cannot be denied to state legislature or the parliament cannot be denied to a citizen, would be applicable. And the court said that this is information that you would provide if the legislature or the parliament were to ask you, and therefore it has to be provided to the citizen. So there are many cases like this where there is a denial which citizens feel an is an illegitimate denial, and they resort to this clause to say that this information cannot be exempted. Now, by removing this clause, this entire possibility has been removed. And like I said, this was not applicable just to Section 81J. The government had brought in the bill. Even at that time, we wrote to the ministry saying that this is a wrong reading. There are judicial orders which do clarify that this doesn't only apply to Section 81J, it applies to all of the exemptions listed in Section 8 of the Right to Information Act. And despite that, the law has been amended, the RTI law, through the data protection law, and they have done away with this proviso, which will definitely cause trouble for people who are seeking information using this proviso as well.
So when you say this particular provision is not only applicable to Section 81J but across the board, what you mean is that it's not only information which is sought to be denied on the grounds of privacy, but also other grounds for denying information, grounds other than privacy, such as national security or whatever it is. If they can be shared in Parliament, then they should also be made available to citizens.
Absolutely. So this is which is why I said that this is actually a much larger blow to the right to information regime, because Section 8 of the Right to Information Act lists out the various exemptions where, as citizens, we cannot access information. It includes information that would have a negative impact on state security or the economy of the country, the economic sovereignty of the country, anything that would cause harm to a commercial interest, fiduciary information that's held in a fiduciary capacity, all sorts of exemptions that are listed, the 10 exemptions that are listed in the Right to Information Act under Section 8. So by removing this proviso, which was applicable to all, where as a citizen I could argue that yes, maybe under national security you can say that this is getting covered under national security, but you will provide it to the parliament if they were to seek it, therefore provide it to me. That gets taken away from a citizen by the removal of this proviso.
Okay, just to deviate from the strict whatever scope of this discussion, I just wanted to ask you, I'm just curious since this came up, what are the grounds under which the government can deny some kind of information to Parliament? Can they, the right to information basically is now turning into a framework for denying information instead of providing it. But under what grounds can similar kinds of information be denied to a member of Parliament asking a question? Can the government say, okay, this is personal information, I won't give you, or this is X? Like, what are the accepted norms of denying information to a member of Parliament? Is there anything like that in place?
I think it's by precedent, and I think that there would be cited, some rules would be cited, there would be some reasons that would be given. This would prejudicially impact the sovereignty of the country, etc. There would be some reasons that would be provided. But we have been told, Sampath, by many legislators, including parliamentarians, that the Right to Information Act, it was being used even by them, because they actually felt that it was a very, very powerful tool to access information in a timely manner from the government. And I would say that this particular provision was very important, however, because there were many cases in which, for example, the issue of NPAs, when a right to information request was filed by citizens asking for the list of people whose loans were written off, the non-performing assets, etc., the defaulters, the loan willful loan defaulters, the matter did go up to the Information Commission. And the Information Commission again said that this is information that should be provided. There is a great deal of public interest. It's public money, it involves public money. And when the government took it to the judiciary, finally the matter in the Jayantilal Mistry case was heard by the Supreme Court, and the Supreme Court upheld people's right to access this information. And this kind of information is also sought in the parliament. We've, of course, seen that even in the parliament, there have been governments who've said that no, we will not give it. There is no public interest, and very often there's been reluctance. But under the right to information law, using the various provisions and these provisos, which actually carve out exceptions to the exemptions, people have accessed this kind of information.
Right. So you spoke about those LPG cylinder thing, and then you also mentioned these NPAs and the willful defaulters. Now, I think a couple of other kinds of information has also come up in terms of what might be denied once this rules of DPDP Act comes into effect, and then the act is enforced. Now, one is, of course, governance related information such as public distribution system related details, and the other, of course, is electoral rolls information, which has also been sort of in the news. So how do you think PDS details and electoral rolls will get affected in terms of denial of information? Because we know that there are also other means and frameworks through which information about electoral roll data and PDS data come into the public domain. It's not only via RTI.
So, first of all, when this law becomes operational, all public authorities are going to make sure that their practices of information disclosure are in line with the new law, which has become operational. So, it is true that a lot of information, which is granular personal information, is available today in the public domain. So, for example, there is information on Manrega workers. You can have very, very detailed information which is available on the internet on who has worked at which site, how much wages they have got in a given day, information on who is getting rations, who's got a ration card, what was the ration that was given, etc. There is information about electoral rolls. So all of this information is in the public domain in many places, not everywhere, but in many places. And a lot of this was not just strictly within the domain of the Right to Information Act. So, for example, the National Food Security Act, when it came in, it said that details of stock registers, sale registers, all of that should be made available to citizens. This should even be an attempt to put it in the public domain. Now, unfortunately, a lot of these laws don't actually define what the details are. So, right now, we see that a lot of states are putting out information in the public domain about the names of the beneficiaries, which is then used by people to do a public monitoring, to do a people's monitoring, and wherever they find corruption, to point it out and make sure that they can get their rights. Now, this kind of information, once the data protection law comes into force, is very likely to be pulled out of the public domain, because the law is saying that that the personal data, which includes anything that identifies an individual, has to be protected. So it's very likely that this information will be pulled down. And although the law says that what is specifically defined in any other law will be protected, but for example, like I said, the National Food Security Act does not go into the detail of saying you have to give the names of beneficiaries, their addresses, etc., which is important for a social audit. It simply says details. So, what we might see happening is that the whole exercise could get shrunk into a simple dashboard. So, details could mean there are 81 crore beneficiaries under the public distribution system under the National Food Security Act, and that's the detail that we are giving. Whereas to do a real accountability exercise to make sure that there is no corruption, the right people who are eligible are included in those lists, somebody is not being denied their rations despite the fact that the record is showing that they are getting their rations, all of that is only possible, that public monitoring is only possible when people have granular data. And if that is removed, this entire exercise will go. And this is true. People, we know how effectively people are doing this exercise on Manrega. Yes, there is corruption, but even where people are able to fight back, and in fact, in the last 20 years, Sampath, there have been about 60 lakh RTI applications that are filed every year in our country. It's the highest number globally. And our research has shown that a majority of these applications are filed by the poorest and the most marginalized, who are being denied their basic rights like rations, like wages, minimum wages, and so on. So these are
This entire campaign, Hamara Paisa, Hamara Adhikar,
absolutely हमारा पैसा हमारा हिसाब, the whole thing about राशन की सूचना का जो पूरा that entire abhiyan, all of it has relied on granular information being available to citizens, which they can then go and check. So there's a verification that citizens do, and they catch corruption, they catch abuse of power, and that's how accountability has been done at the grassroots level. That's going to stop. Now, again, when you talked about electoral rolls, the last few elections, we've seen repeatedly there have been concerns about deletions and additions to the voter list, which have been allegedly incorrect. Now, one of the ways by which in a democracy citizens can actually participate, they can check whether the right names are there and who are allowed to vote, and just some particular community is not being excluded from the voter list, is by checking the voter list. Now, the voter list has our names on it, it has our addresses on it, it has our photographs. Now, all of this is personal information, and once this law comes into place, there is a very strong likelihood that the election commission might sort of look at its practices and pull down these lists, saying that this is no longer in line with the law of the land. So yes, this was not something that was somebody was accessing under the right to information law, but this was made available to citizens. It's done in democracies across the world, most of them, to prevent electoral fraud. But now with this law, it could very well happen that this is pulled down. By the way, the Election Commission of India used to put the electoral lists in a searchable format so that anybody could easily look at that data and figure out what was happening, do a search, etc. Already, in the name of data protection, the Election Commission has removed that element. They have now just put photographs of the PDF. And so now no longer can you actually search in the voter list and look for names. You have to go through each photograph, which means that it's a far more cumbersome exercise than before. And, we are potentially looking at a scenario where we might not even have access in the public domain of the electoral lists, and then how do you prevent electoral fraud?
Now, this is of course very concerning, but there is something else which I found pretty bizarre, and I think it's a matter of concern for all journalists as well, journalists in particular actually, which is this whole idea of data fiduciaries. So, if I understand this correctly, if I am a journalist and I am filing an RTI request about some public official, and I have not taken that public official's consent because I suspect there might be corruption involved. So, in this scenario, would I be classified as a data fiduciary, which you associate with somebody like Twitter or whoever? And then, would I be fined for seeking in public information, public interest-bearing information about this official? Is that how this whole data fiduciary thing works? What is this data fiduciary aspect of this law? Can you please explain it for us as it impinges on journalism?
Yes. So, there are two ways in which citizens can access personal data. One has been through the Right to Information Act, where one makes an application, which will now become virtually impossible after this law comes into being. The other way in which citizens, especially journalists, have collected personal data is by going out into the field. There'll be a survey that is done or a fact finding that is done, and data is collected. If there is some information in the public domain, they'll process that personal data and come up with a story. They'll analyze that data that is available and put out a story. Now, what is going to happen under this law is that not just our ability to access information under the RTI law is being curbed, but also this entire sphere of citizens collecting personal data in any form is also going to be hugely compromised, because what the data protection law is saying is that anybody who collects personal data, it could be somebody who works in the field, just simply takes down the names of people who are not getting ration cards, to help them or whatever, a small organization, or somebody who's just, a volunteer working with some, helping with some work, they will be covered as a data fiduciary, and journalists will be covered as data fiduciaries, and of course the large companies will be covered as data fiduciaries. So this, I mean, it makes no distinction, the law, and covers everybody who collects any amount of personal data as a data fiduciary. And then the law goes on to say that their chapter 2 of the law, if one looks at it, lays down a whole host of obligations on them. For example, you have to go out and get consent from the person whose data you're collecting, and only if you have consent can you collect their data or process their data. And processing is defined as any kind of automated, semi automated process. So I mean, typically, one can imagine that somebody is going out, a journalist or a citizen is going out and just doing a quick survey or writing down the names of people and taking a picture of it. Now the moment it becomes digital, this law becomes operational, and we know that, a lot of work today is done in the digital space. So this is now saying that if you don't take consent from each of those people, you are violating the law. There are anybody could be identified as, the central government has the power to call them significant data fiduciaries as well. So they will have even more obligations, like putting in place a data consent manager, or data audit manager, etc. So it's a very cumbersome exercise. Now if somebody says that I want to complain, my data under the data protection law, there's been a violation, they can go to a data protection board. Now this board is a purely sarkari board, which basically means that the central government has said that they will decide how many members this board will have. The central government will unilaterally decide who will be the chair and the members of the data protection board. The power of removal of these people will also be with the central government. It's effectively a government department, the central government department, to whom the complaint will go. And this data protection board is being empowered to put penalties up to 250 crores, which can be doubled to 500 crores. So on every case of violation, the law says that the data protection board can put a penalty of effectively up to 500 crores. Now this is a huge amount for journalists, for small organizations, campaigns that work on the ground, who bring out very important information in the public domain, who are also dissenting voices. This is a huge problem, because what then is happening is that the central government is controlling the collection, the processing, and the entire framework of personal data. So the fear therefore now is that this law will become like a weapon. It's a weaponization of personal data, where the central government is saying that they will also, in fact, this is very important, the central government is saying we will decide who is a data fiduciary and who is not. So the concern with data privacy, or the right to privacy activists, is that how is this arbitrariness then going to help people? How is their right to privacy going to be protected? So in fact, it's not just right to information activists, even right to privacy activists have been speaking against this law, because the government is the largest repository of personal information. Under the Aadhaar, the UIDAI has all our biometrics, all our personal information is with them. So they are saying state instrumentalities will be exempt from the law. any private entity can also be exempt from the provisions of this law, several provisions, if the central government so chooses.
So
So
does this mean that the government is saying no one else can even collect data except for us and people whom we like? Is that what it means?
effectively, yes, that is what it could mean. Anybody who's in power at the center, today it is the BJP, tomorrow it could be some other party, but effectively, what this law is saying is that if you are a state instrumentality, there is an exemption. If the central government wants, they can exempt certain entities, maybe their friends in the corporate sector, certain capitalists could be exempted. And maybe certain media houses could be exempted, maybe certain social media IT cells of certain political parties can be exempted, and everybody else will be covered under this law. And if there is a complaint against anyone who is covered under this law, then the complaint will go to a data protection board, which is a completely central government controlled board, which can impose penalties up to 500 crore rupees. So let me just illustrate this with an example. So many bridges have been collapsing, we saw in Bihar, one after the other. There was a lot of concern. People might want to access information under the RTI law as to who the contractors were who were building these bridges. A whole host of other information on who was responsible for deciding who the contract will go to, the name of the public official, the name of the contractor or the company, etc. Now, all of that information might in any case now be withheld from us under the RTI law, because we'll be told, you can't have this is personal information. A journalist might go, however, and do their fact finding and come up with the names of people who were doing all of this or allowing or facilitating this works. And if they have to go ahead and process that information, publish that story, they will need consent from those people. Now, what are the chances that the people who have been indulging in corruption, who have been indulging in wrongdoing, are going to give consent? So that means that if journalists go out and publish data like this, because there is no exemption for journalists, if they go out and do this, there could be a complaint to the data protection board against the media house, the journalist, etc., and they could be fined up to 500 crore rupees. So effectively what is happening is that journalism, because there is no journalistic exemption under the law, could be really turned into propaganda, because whatever the central government sort of, or the person who's indulging in corruption wants you to publish, is all that you can publish. And the intent of this law is also under question, because the previous two iterations of the DPDP bill actually had a provision for journalistic exemption, and that was clearly removed. A lot of the data protection regimes across the world have an exemption for journalists, because you don't want to impinge on free speech and expression in such an obvious way. You don't want to curb media freedom. But what this law effectively is doing is, by not allowing us to access information, it's coming down on citizens' right to information and therefore free speech and expression, because the Supreme Court has held that right to information flows from Article 19(1)(a), and it goes ahead and it is completely destroying the media freedom space. So it's very dangerous in any democracy, because what doesn't suit the central government, therefore, doesn't come out in the public domain. Any dissenting voices on the ground, any journalists that put out truth that is inconvenient, show truth to power, so to speak, could very well be targeted using this law. And that's the fear, that, this is like a weaponization and of personal data, and this is actually adding an something to the armor of any government who's in power at the center, to go after people who they want to silence, because they're pointing out things that are not convenient.
Right. So there are two sides to this entire data ecosystem that is going on, that is likely to unfold, is how I see it. One is, of course, the state controls what kind of information comes out. So, and as you said, if the RTI is sort of diluted, especially with this provision to such an extent, the only information that can independently come out of the state without the government directly putting it out is what it would allow to come out. Then it is controlling what comes out into the public domain very clearly. And most of the time, it would be PR kind of information or the official version. And secondly, it is also controlling what kind of information is created and collected. Because if you are going to be collecting certain kinds of information, you automatically become a data fiduciary, and you could face the stick at some point because you may or may not have taken consent and so on and so forth. So both what information is collected, what data is collected, and what data comes out is now sought to be controlled by the state.
And if I may just add one other thing, which I think is very relevant, is that even data that is in the public domain. So, if we were to take the example of electoral bonds, the Supreme Court pushed the SBI to finally put out data on who gave money through electoral bonds to which political party. This was put out in the public domain. Processing of that data is also now covered under the law. So that means a journalist who doesn't even collect data from the ground but is using existing information in the public domain, if they run any automated process, we saw how very quickly journalists got into the act in the electoral bonds exercise and asked, very quickly told people in the country that, there appears to be this quid pro quo that was happening. Money was given by this engineering firm to this party, which then gave them a contract within this time. All of that was through publicly available data. Now, that is also going to be subject to this law, because the law says not just collection, but also processing of data. So that means journalistic work, in a sense, is going to really be.
So what happens if I process the data? Like, how am I affected?
You are a data fiduciary, and unless you have taken consent and processed that data. So,
So
for
to
example,
process the data, I need to take. But I didn't collect the data, so why do I need to take consent?
because any personal data that you use, even to process, you have to take consent from the person whose data it is. So let's say one gets information in the public domain tomorrow. There might be let's say a Supreme Court judgment, hypothetically, which says that information has to be provided on who all are giving how much money to which political party, etc. Now that information is there. What this law will ensure is that you cannot at all process it, or use any automated processes, linking up and coming up with anything. Even a summation of something is an automated process today. You do it in Excel. To do it, you have to first go and take consent from the people whose data it is. Otherwise, there would be a violation of this law. So this means that even data that's available in the public domain, for journalists to use that data will become completely impossible unless consent is taken from those people
Or
whose
maybe
data it is.
unless I don't use any automation, I use Vedic mathematics to maybe. Sorry. Okay.
On paper, please.
On paper, yes. Okay. Sorry about that. Now, so all this is sort of we've established, all the issues with this. So what next? What's the way forward? I mean, is there any possibility that we could convince the government to sort of reconsider this provision and maybe repeal this particular section? Is that likely, or is there anything that is likely to happen if it is taken to the courts?
So, Sampath, what is happening on the ground is you know, creating awareness about this law that has come. Unfortunately, there is very little awareness. When the law was passed, the bill became an act in Parliament. That was in August 2023, when the Manipur issue was raised in the Parliament, and there was a no confidence motion, and the opposition walked out. So there was absolutely no debate in Parliament when this law was brought in. And awareness about the law is very limited amongst people as well. It is now sinking in that this law is going to become operational, because the rules, like you said, are being drafted, and the government has now indicated that this month itself they might promulgate the rules and the law will become operational. So there is now an urgency, even amongst citizens, amongst political parties, to take this issue up. And we've of course written repeatedly to the minister concerned, Meti Minister Mr. Vaishnav, to say that, look, you have to review this law. Specifically, the right to information movement, the campaigns have written saying that Section 44.3, which amends the right to information law, must be repealed. And the data protection law says that each of the provisions, there could be a separate notification of when they will come into effect. So the first demand, of course, is that don't bring Section 44.3 into effect. Don't pass a notification to that effect. And but I really think that the entire law, the way it exists today, neither protects the right to privacy nor the right to information, and it needs a very serious review. So the larger demand remains that the entire law, before it's operationalized, must be reviewed. There must be committees, the IT.
Wasn't it already reviewed by the Parliamentary Standing Committee?
The law has gone through various consultations. There have been problems with it because consultations have been done in a manner which has been very exclusionary for a lot of people whom it will impact, like only in English, only online, which really leaves out a very vast majority of the people who will be impacted by this law, largely with industry, which we don't mind. You must consult the industry, but what about people whom it's going to impact? Also, the JPC, which was set up to look into the bill of this legislation, we've spoken to the members, and this became news as well at that time, where they said that we worked on it for a year, and finally we were not even shown the final bill that was taken to Parliament. It was passed without even sharing it with the members at the last minute. So the consultation has been not adequately open. It has not taken on board, for example, the National Campaign for People's Right to Information, the Right to Privacy campaigns have written repeatedly. No time has been given to present the matter before any of the committees, and the government has not taken on any of these concerns on board. So the demand really is that there should be a proper consultation, and only after that, bringing in required amendments, changes. After all, the government keeps amending so many laws. I mean, there is very clear need in a democracy to not bring in a law like the DPDP Act in its current form. It needs to be amended properly before it comes into effect. Otherwise, it's going to really, kind of take us, into a place where we can't really be called a democracy. Section 36 of this act, Sampath, says that the central government can ask any data fiduciary for any information under this act. Now, where are the guardrails? So, you're saying that we want to protect your privacy, but you empower the central government under Section 36 of this law to say any data can be asked from any data fiduciary or the board. So, these are the kinds of things which can be really sort of not just the right to information, of course, that's there, but what about the right to privacy as well, touting which they have brought this law. So this needs a very serious review. That's the demand. There have been many campaigns that have come together. There is sort of campaigns that are taking place on the ground, signature campaigns, other kinds, where people are asking the government to review the law, to not operationalize Section 44, which amends the right to information law, but also look at the entire law and make the necessary amendments through Parliament before it's implemented.
I think that's all I have for you this time, Anjali. I think I really liked one thing you said today, which I think should be the spirit in which both these acts should be reviewed. As you said, they need to be reviewed, especially the Data Protection Act, and especially that amendment which is sort of on the cards, which is that when you said public authorities are custodians of our information. I think that is the spirit which is completely missing from the Data Protection Act, and that is the spirit of the RTI as well.
And the Niti Aayog, Sampath, actually wrote to the government saying that there is a concern. There will be a lot of information about public officials that should be made available in the interest of public accountability, and you cannot bring in a law in this shape and form. And even the Niti Aayog was not heard. So, like you said, assets and liabilities of people who are contesting elections, those are put out in the public domain. Personal information is there because it's necessary. The Supreme Court felt it was necessary. A whole host of things. We've seen what's happening in the judiciary with the Justice Verma matter, where there is judicial corruption's allegation of judicial corruption, and people are asking for the assets and liabilities of judges as well. Now, all of that information is very important for citizens in a democracy to have. And the Niti Aayog itself wrote to the government, to the MeitY, and said that bringing in this law will mean that all of this will go outside the ambit of people's access to information, and the law should not be brought, and yet it was rammed through.
Right. I hope the Niti Aayog's voice carries some weight, if not that of the citizens. Thank you so much, Anjali, for coming to our office, making time for this conversation. Pleasure talking to you.
Thank you.